Ladies and gentlemen, welcome to today's webinar. Today's seminar presentation is from our first 30-minute series. Today's topic is assessing financial obligations with debt and credit facility workout strategies. Our presenter today is attorney Eric Boughman. If you'd like a copy of today's presentation, you can find it in the handout section of the webinar interface. Similarly, if you have a question, you can type it into the question section of the webinar interface. And now let me turn it over to Eric. Go ahead, Eric.
All right, thank you very much, Tony. Thank you everybody for joining us today for another session in our first 30-minute series. The background on this is that we talk for about 30 minutes here, and these are topics, things that come up. I try to cover very relevant topics and discussions that come up with clients, oftentimes either with a new client or in a new meeting regarding an issue that comes up. And these are the high-level issues that we might discuss in the first 30 minutes or so of a consultation. This topic that I'm talking about today, it's kind of bittersweet. I'm excited to be talking about it because there's a lot that we can do with it. It's an issue that's probably the thing that I've been asked most about in the past month since this whole COVID thing started. And it's also something that I think is going to be a huge issue going forward over the next, several months, going through to the end of the year. And if I'm wrong, then I will be happily wrong. The topic is in connection with our recovering from the whole COVID crisis, not only health-wise, but how do we do that financially? And for a lot of folks whose businesses have experienced a significant slowdown, particularly our healthcare clients, some of our professional clients, where businesses, essentially come to an almost standstill for a temporary time here. How do we address that coming out of this? Once we're healthy and ready to get back to work, what do we do with these financial obligations that we have hanging over us? And what can we do as far as moving forward, maybe with a clean slate, or moving forward and getting some of this pressure off? As a lot of folks know, we do a lot of asset protection work here in the firm. We try to prepare clients both from a corporate standpoint, from a personal standpoint, on insulating themselves and protecting themselves so that in the event something bad happens, you have some protection, insulation, and some leverage in dealing with creditors. But a lot of folks don't do that. And a lot of folks are going to be in a situation now where they're wondering really, what their options are. Bankruptcy may be a consideration, but for a lot of professionals where they have to report financial status and there's some level of financial analysis or financial responsibility that tags to their license or certification, that may not be the most palatable option. And there's some other options and strategies that we'll take a look at. So we're going to cover that. If you have any questions along the way, I hope you'll shoot them to me if I don't cover something here, or if you think of something afterwards. I always welcome a follow-up phone call or email, and we can try to address it after. So here's our agenda. I'm not going to spend too much time on this. We're basically going to, it looks like a lot. We're going to cover all of these essentially slide by slide in a very high level overview. You should have all of these materials. And this, what this agenda on this particular presentation looks like is essentially it's a checklist of things that we will go through. If I meet with a client, I'm looking to see, what kind of financial exposure they have, business and personal, and what kind of leverage we can create in negotiating or in salvaging some type of good financial situation out of a crisis. These are the issues that we're concerned with, and this is what we're going to take a look at. We're going to start with just, how do we get in this situation? And, COVID obviously has given us a health impact, but it's also had a financial impact. And the financial impact for, obviously for healthcare workers is one thing, both on a risk assessment, health and lifestyle stress and strain that those folks are under. But we also see it with other business owners. We see it obviously with restaurant owners, hotels, anybody in the entertainment industry, live presentations. If you are in the business of providing support, whether as a hotel or some other facility or vendor for live presentations or for travel, you're obviously affected by this very substantially. If you are, perhaps if you're in the computer industry, in the tech industry, you do something online, or if you're in shipping or trucking, maybe the impact has been less, or maybe this has been a good thing for you. For business owners, if you look at restaurants and other service providers, maybe hotels and tourist type destinations, tourist type attractions, there may be a lot of physical assets, and really a lot of the value may lie in real estate and positioning and name, reputation, and assets. But for service professionals in professional services and healthcare services, everybody from the dentist to the primary care physician to maybe some attorneys, financial advisors, they have a unique situation because the primary value in their business is the personal services that they provide and that they're qualified to provide. And that creates a unique situation from a standpoint of viewing, what the asset value is and what the value, the inherent value of the business is. There's oftentimes a very different going concern value for a business than there is a liquidation value. On another issue or another level, you have the again, what I mentioned earlier, the financial impact on licensing. Most folks who have a professional license, there's some degree of reporting required for financial qualification, for financial responsibility. The bankruptcy code, and I'm not a bankruptcy lawyer, but I do know that the bankruptcy code prohibits generally disqualifying somebody from a profession or from a license solely based on filing bankruptcy, but that doesn't account for all of the other considerations that can go into evaluation of a professional license. If you're a lawyer, for instance, and you have a lot of debt and a lot of bad debt and financial issues and a history of financial, what the bar would consider financial irresponsibility, that could affect your ability to get licensed or to maintain your license. So because of those issues, the unique factor of the value of the assets being in the services, and the fact that a lot of folks are not going to want to look at bankruptcy as an option, personally or business-wise, we need to assess and explore other options. And in doing that, we start first, if we're looking from a business perspective, we start with the business exposure. Look at the business itself. What kind of obligations do you have? Do you have a lot of loans? Do you have equipment on lease? Do you lease property? Or do you have a situation where you're an owner operator in the property? Is that lease shared? Is it short-term or long-term? Is it up for renewal anytime soon? Do you have an ability to renegotiate or to potentially move? What's your situation with employees and with taxes, vendors, and third parties? And when you take a look at all these obligations, you're going to evaluate those in terms of, what happens if you don't pay those. You're going to have obviously a business ramification, but some vendors are, frankly, used to being paid on terms, and sometimes there develops a pattern where parties will work together on reduced amounts for payment. Other folks, maybe some lenders and some other creditors that you have are not going to be so willing to negotiate. And you may need to take a look at what your leverage situation is with those particular creditors. That will at least have some degree be affected by what the ramifications of default are. If you're renting space for a dental practice, for instance, and you don't pay rent, you can expect that, at a certain point, the landlord, even though right now here in Florida, my home state, we're in a situation where nobody can really evict anybody because the courts won't issue writs of possession. That's not going to go on forever. And if you are not paying a lease, you're eventually going to be looking at a situation where you need to either do a workout or make plans long-term for leaving. And when that happens, you need to know what the recourse liability is. Is there, how much liability can you be looking at if you're in a commercial lease, for instance? Is there an early termination clause? Is there an ability to walk away without long-term debt piling up? Or do you have, are you under, for instance, maybe a 5-year or a 10-year lease that has an acceleration provision? So leaving now in year 2 or year 3 of a lease, has serious long-term ramifications because you're now looking at 10 years of lease payments being accelerated. Those are the types of things you want to look at from a business perspective. You want to look at what's going to happen if you don't pay people now, if you reduce them. Are you able to negotiate with these folks? If I'm on the other side and I'm working with creditors in this situation, I'm going to want to take a look at the long-term history and what the relationship has been with a tenant or with the person that they're dealing with. Is this something that's been an ongoing problem for years and now it's just exacerbated by the recent events? Or is this a situation where you've got somebody who's been a good business partner, a good tenant or a good a payer under an agreement who now can't perform because of what's going on? And but depending on what those factors are and what that situation is, I may encourage my clients who are looking at this from a creditor perspective to be more willing to work with folks on the other side. And I will also use that if I'm representing, if I have a professional healthcare provider who's been in the same location leasing space for several years, and now we're not seeing patients as we were a few months ago, and we're having a hard time keeping up with the payments. I will use that long-term reputation, long-term history between the parties as a negotiating factor. Hopefully by now, most people are operating their business and their different business interests separately. If you are, again, if you're a service provider and you own the building that you operate out of, you hopefully own that building in a separate entity as the practice that operates, and you have a written lease. We encourage insulation between various entities and assets and asset classes. And then the next thing we're going to look at is what's your personal recourse and exposure. Do you have personal guarantees? Are you a personal debtor on these obligations? And that's going to influence the next steps in our evaluation and strategy. So when we're taking a look at this beyond the business debts, and we're taking a look at what your personal situation is, we start with the premise that shareholders of a corporation, members of a limited liability company or a limited partnership, generally are insulated from the business debts. There's several exceptions to that. There's some states have laws, including Florida, that can make you obligated for malfeasance or bad acts when acting in a management capacity. If you're a business manager or if you're an officer or director of a company and you do something that hurts someone, or if you engage in some type of fraud, you could be personally liable. Hopefully nobody here is looking at that type of situation. Professional negligence generally cannot be insulated through a business. So if you are a professional, a lawyer, doctor, somebody who is potentially being sued for some type of malpractice or negligence claim, you're not going to be able to eliminate that claim or be insulated from that claim through your business. We also have veil piercing. And piercing the corporate veil, the term gets thrown around a lot. I will tell you that in Florida, Florida generally follows Delaware law on veil piercing. Very tough to pierce the corporate veil in Florida. You will hear creditors who will say, well, even if you think you're protected through your business entity, we're going to come after you personally. Unless in the state of Florida, unless you are essentially using your business to commit fraud, you're not going to be able to pierce a corporate veil in Florida. Some states consider fraud as one of many elements in the piercing analysis. And I should specify, piercing the corporate veil is essentially treating the company and its debts and obligations and the individual as one and the same. In a veil piercing situation, your business entity that you operate through is going to be looked at as an alter ego of you personally, so that you're personally responsible for the debts. That's not going to happen in Florida. It's not going to happen in Delaware unless you've been using that entity for a fraudulent scheme or purpose. But if you're operating a legitimate business entity, if you're running your healthcare practice or your accounting practice through an entity, nobody's going to pierce the corporate veil to get to you personally. The most common that we're going to see here is personal guarantees. And I try to keep my clients as much as I can. I want to avoid signing personal guarantees most creditors, landlords, other folks will ask for them. Loans often won't get done with large financial institutions without a personal guarantee. But if you have a long-term history and relationship, sometimes you can get credit and loans extended without personal recourse. On leases, it oftentimes comes down to your negotiating leverage. It's too late to look at this now, but when entering into a lease, you can oftentimes limit the personal guarantee to a certain dollar amount. So even if there's an acceleration and a large debt due under the lease, maybe the personal guarantee has a limited extension. You can often get sunset provisions on personal guarantees. You can get creative with those. And when we're doing this analysis and we're looking at exposure, we need to take a look and see, what type of personal exposure might you have, and mostly that's going to come from a personal guarantee. So once we get to that point, we say, okay, you've got your business, you've got your, the personal responsibility for certain business assets, things that can trace back to you. We know that your business is one where even though you're operating through your business entity and providing some type of service, the real value inherent in your business is that you continue to perform those services as a going concern. You're providing your expertise, knowledge, your license, your reputation, your relationship with clients and referral sources long term. All of those values really can't be bottled up and encumbered by a creditor. So we need to take a look at, what is your exposure? And then once we figure out your exposure for the business assets, now let's look at your personal exposure. And this is, again, where we come back to, clients who've been longtime clients of ours who have insulated personal assets further through some type of asset protection structure are going to be much better positioned than clients who haven't really taken a look at that long-term concern. These could be things such as something as simple as statutory exemptions. If most of your wealth is tied up in financial accounts and life insurance and annuities. And when I say financial accounts, I should say retirement accounts, education accounts, and things that have statutory exemptions, you're going to be much better protected. If you are married and you have most of your assets titled as marital assets and tenants by entireties, and you individually are a spouse who operates a practice, maybe signed a personal guarantee, that personal guarantee is not really going to be worth much if you're the only one who signed it. I have seen situations where creditors will try to get the spouse to sign the guarantee, but if the spouse isn't on the guarantee, then your tenants by entireties, your marital assets are not exposed. So we're going to take a look at those things next. After we get through the business, look at what business debts extend to you personally. Now we're going to look at your personal exposure and see, okay, if everything folds today, what among the assets and the things that you have, what's at risk? And this exposure analysis is what's going to influence our negotiation leverage. This is what we're ultimately, when it comes down to it, when we're talking to creditors, this is what we're going to be looking at. And to give somebody on the other side, a creditor, whether it be a landlord, a lender, or somebody else in that position, okay, if we can't work something out and get through this together, the situation that you're looking at is, yeah, maybe you get a short-term remedy, you get to force me to stop operating, but you're not going to get paid. And so you need to use that leverage to create a situation. This is what we want to do with our clients, is create a situation where now we are essentially operating from the same viewpoint or the same vantage point as the creditor. The creditor knows what the situation is. We know what the situation is. Let's work together to get them paid and keep you in business. And what happens if we can't do that? Then what are your options? I have a caution here, late stage transfers. If you're trying to move assets around, oh my gosh, I have this account, I'm going to move it. We do a whole separate seminar on fraudulent transfers and that whole issue. You generally want to avoid that. Now there's an exception here. I did one of these sessions a few weeks ago on the impact of COVID generally on your opportunities to engage in some long-term planning. If you are in default on a debt right now, you can't move assets to avoid that creditor. But if you're not in default, but just the COVID situation has got you thinking, oh my gosh, what if something really bad did happen? I can weather this one, but it really got you thinking about your long-term planning, your estate plan, your asset exposure. That's perfectly okay. You can use this situation now to engage in some long-term planning. Now, I put a note here about the gray area. What about the situation where, and this is what I get commonly asked, what about the situation where everything's good today, and if we recover and we're out of this in a month or 2 months, we're fine. But if this extends into 2021, we're going to have some long-term problems here, and I've got some debts and obligations that might be defaulted. Can I do something today to protect myself personally from the exposure that might come from those debts and obligations? And the best answer I can give you, it's a total case-by-case analysis. That's the total gray area. I give you a bright line. If you have a default today, you can't move stuff to avoid that creditor generally. It's a couple exceptions, but generally you can't move stuff. If the skies are clear and everything looks good and you're just thinking about doing some long-term planning, you're fine, you can do it. And so there's a bright line where you can't do something, there's a bright line where you can do something, there's that large gray area in between. So now that we've gone through your assets, we're going to look and see, okay, what assets are exposed? What kind of things do you have in accounts that a creditor can get to? And what assets are protected, either because they're statutorily exempt, they're in entities that are designed to insulate those assets. They may be in trusts, maybe the self-settled trust or some other trust mechanism. Once we figure that all out, we divide up your personal assets, we figure out what's exposed, what's protected, and now we want to act based on that analysis. And depending on the situation you have with a creditor, we may change some of your behaviors so that you're maximizing preservation of protected assets, and you are on a day-to-day basis relying solely on exposed assets, because if you don't do so, they're ultimately what's going to be available for a creditor if things go really bad for you. So as I noted in the beginning, you're negotiating leverage as a professional provider. If you are a dentist and you've got leased space and a lot of your equipment is leased, you've got employees, you've got other obligations to vendors, but a lot of these obligations are all tied to that equipment. But what can't be encumbered and what can't be foreclosed upon or taken by a creditor is your license, your education, and the personal services that you provide. A dental practice is worth significantly more when it's operating than when you just liquidate the assets and try and sell them, especially in this environment. And I've gone through this. I'm going through this right now with clients. Your situation, your leverage is much greater than what you may think, because the lenders also know that. The lenders know that we can't go in and just shut down a practice, knowing that if we do so, we're going to be lucky to get 10 cents on a dollar for our assets that we have secured. Plus, lenders have to deal with the fact that landlords may have a landlord's lien, so now you got to look at who's got a priority there. You have a specific advantage here as a licensed provider, and in the fact that you have services that you can carry on to a new business. So then the next question I might be asked is, well, can I just close my business and reopen? Can I just open up a new practice tomorrow and just take my relationships and take my everything that I've been doing over the last 10 years that's all in my head and open up a new practice? And the answer is yes, but very carefully. And you can't take your assets from your current practice and move to a new practice, but you certainly can take some of those assets if you do it in a proper way and you account for them and you do it in a way that accounts for your current situation and your current creditors. Pardon me. So is this fresh start possible? Can you do it outside of bankruptcy? Can you do essentially wind down your old practice and begin a new business? And the answer is again, yes, but you can't just close and reopen. And I'll give you an example of where that went bad. So when we're doing that, the issue that we're worried about is successor liability. We close a business, we open up something new, we close, ABC. We close ABC healthcare today, and tomorrow we're going to open up XYZ healthcare. We're going to have the same patients, we're going to have the same equipment, the same employees, same staff, same office manager. We're in the same location, same people are providing all the services. That's going to be a big no-no. The reason for that is that Florida law and many other states, I've looked at this for clients across different states in the country, provides many mechanisms for a creditor to go after a successor entity under under the theory of successor liability, either through an implied or express assumption of the obligations of a predecessor, through these other theories, de facto merger, mere continuation, or a fraudulent transfer, as I noted earlier. And so, in a few minutes that I have left, I'm going to give you an example of where this happened, and it's sort of a lesson of what not to do. And this is in this case here, Monell MD PA via Czar MD. This is two doctors that were involved in litigation several years ago here in Florida. And the Monell practice was sued and ended up having a big judgment being entered against it. And the physician owner, 12 days after that judgment was entered, the physician owner incorporated a new business and essentially moved all the assets of the old practice into that new business. They stayed in the same building, they used the same furniture and equipment, employed the same office manager and staff, saw the same patients with the same patient records, and all of this was done essentially with just a name change. And we see other cases. There's another one that I've written about, and I may cover this in a later session, where one of the companies was so brazen as to actually write a letter to their customers and say, please note that we've changed our name. And that's what this was. The Monell case is essentially same business with a new name, same operators with a new hat on. And not surprisingly, they got sued, and the creditor, in that case, who was owed the money under the judgment, asserted several legal theories and said essentially that these legal theories amount to an argument that this is just a continuation of the old business with a new hat on. And so what we learn here is the mistakes that the doctor made was essentially trying to shed the old business obligations while retaining all the business assets and failing to create a separation. How do you do that? Again, there's many ways, and it all depends. It's a case-by-case analysis. We've had businesses where you take on new partners. Maybe you have investors or somebody that comes into, a couple people are going through a similar situation, or you've got a new operator, somebody that can come in with new business, and you end up with new business partners. Or if you're in an LLC type entity, it'd be new members. You may have a separation. Maybe a couple members decide to separate and split. Maybe you're in a situation where you're one of several and you want to break off on your own. You create some type of separation, and then you account for the old assets. If there's security interests under those assets, then you got to let the creditors have their rights to enforce their security interests. Same thing with the landlord. If you're obviously, if you owe a landlord money, if you're in a situation where you owe space rental, you have to account for that. You probably need to move into a new location. If you're going to take patients and customer records, there's a value there, and we'll usually suggest that some value be paid to the old practice. And so what happens to that value that gets paid to the old practice? Well, then that old practice is essentially kept alive. We keep the old value on life support. Any money that you pay, you figure out what the fair value is to pay for those for the transfer of those patient records. And you pay that value to take it on to the new practice, and then that gets held for the benefit of your creditors. And then you can use that to negotiate with and settle out with creditors. And it's generally going to be substantially less than full value, but at least you're not just taking the assets and transferring them to a new practice without paying for them. So what might the doctor have done here? As I noted already here, relocate the practice is an option, create or dissolve specific partner relationships, liquidate the assets, and to the extent that any are not encumbered, liquidate those and use the funds to pay the creditors, or buy those assets into the new practice and use those funds to pay the creditors, and consider what the fair value is for what you would pay, even if you were going to buy this from a third party. Of course, it's fictional because you're essentially buying stuff from an entity that you control into an entity that you control, and nobody can really come up with a good value of what those relationships are worth. But you got to figure out something that protects the creditors, and consider yourself in a situation of being like a trustee for the creditors. If you are a trustee and that's what the court's going to look at. If you have a business that's winding down and not going to be able to go forward and it's going to owe creditors money, your duty is now not to shareholders. Your primary duty is to those creditors. So what would you do to try and maximize value? Well, you try and sell what you can, get a decent value for it, pay the creditors. They're not going to be happy, but at least you protect yourself and you avoid these successor liability issues, or at least you can defend against them. So the point is here is that there are some refresh options available. You got to go through the proper analysis. Once you do that analysis, that will influence your negotiation leverage, and then you have options beyond there. Hopefully we can work something out with your creditor, and you can do this yourself. You can work through counsel or other advisors. I'm happy to talk to anybody about it. I deal with other attorneys and folks all the time where we just work on this particular aspect of a relationship or a situation, and try and figure out what kind of leverage we can create to create the best situation for our client. Maybe that's continuing forward, and maybe that is just through some type of wind down and restart. So the final point here, COVID-19 is not just a health crisis, but an economic one. And it's going to have long-term ramifications, and the recovery is going to require careful planning. So with that, I wrap up another session of our first 30 minutes. Thank you for joining us today. As I mentioned earlier, I didn't hit any questions today, but if you do have questions, anything that's come up from here, if you would like more detail or want me to elaborate on any of the on the Monell case or any other situations, I've written an article about this, by the way, on the blog that I write at flhealthtechlaw.com. It's in our notices. So I write a blog. I also did an article that's going to appear in Kiplinger's over a series in a couple weeks, and I'm going to be covering this in more detail in a longer seminar for the Florida Bar in about a month. With that, have a great rest of your day, and stay safe out there. Thank you.